Arturo Javier Zamora, you are muted right now. You need to unmute. You are muted, Mr. Zamora. There's a button that says mute and unmute. It's like a microphone with a stick across it. Mr. Zamora. There
I,
you
I,
go.
I think I got it.
All right, you got it now. Would you raise your right hand, please? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Thank you. You may put your hand down.
Thank you.
Mr. Zamora, there are several rights and constitutional protections that I'm going to discuss with you verbally, and then we will cover them probably in duplication in writing in different papers.
Okay.
It's my impression that you've already reviewed all those papers with your attorney, Ms. Hikyu Lee. First of all, in any criminal proceeding in the United States and in Texas, you have what's called the right to remain silent. That means that you will not have to make any statement. You don't have to answer questions. You don't have to submit written paperwork that has your signature, especially papers that admit or confess to wrongdoing. Do you understand you have that right to remain silent?
Yes, Your Honor.
You have a right to a jury trial. 6 people selected from at random from a pool of people that your attorney and the state would select from, pick out 6 people that would uh, hear the case and decide whether you are guilty or not guilty. That's a right to a jury trial. You have a right to confront witnesses. Anybody who would testify in a trial, you have a right to question them, cross-examine, challenge them. That would be done usually by your attorney. That is a right and a protection. You also have a right to what's called a right of appeal. That right is a right that you and your attorney would exercise by, in a proper manner with the right papers and timeline, you would demand that a higher court review the official record in this case, and that you would, for whatever challenge you wanted to make. That's the right of appeal. You and the state, by the way, both of you have the right to demand that this hearing be held in the public courtroom. Right now, we're not holding public courtroom hearings because of the COVID pandemic. So, uh, those rights that I've mentioned to you in a plea, as you are doing, you give those up. Did you review those with your attorney and understand that you are giving up those rights?
Yes, sir.
All right. Do you have any question right now?
No questions.
Okay. Now, we're going to show you some papers, some documents. All of them, with maybe one exception, will have at the top what you see here, the basic information that identifies you, the court in this case. This is cause number CC 657675, the state of Texas versus Arturo Javier Zamora in County Court at Law number 5, Bexar County, Texas. Now that's the what I call the basic information. Then from there on, the documents will be identified. This one says states consent to video conference. This one I mentioned a while ago that the state, you and the state both have the right to a hearing in a public courtroom. This, because of the COVID, this one has been signed by Ms. Caitlin Morgan on behalf of the state, declaring that they consent to doing this by video conference like we're doing here. Now I'm showing you a document called Discovery Acknowledgement. It has the basic information at the top, the identifying information. Then this talks about a law. The very first sentence up there says Article 39.14 of the Code of Criminal Procedure. This talks about a law that requires, it is a state of Texas law that says that the prosecutors, the the district attorneys have to provide access and availability to you and your attorney. All receipts, documents, videos, everything that involved in this case by way of evidence or information, so that you and Ms. Lee can make an intelligent and informed decision. This is signed by Ms. Morgan for the state and Ms. Lee on your behalf as defense counsel, saying, yes, we have obeyed this law. Are you aware of this document?
Yes.
All right. The next one is your own, where you consent to the video conference. You did that a while ago verbally. Now here we show on the record on these documents, all of which will be placed in the record. This one has your signature where you agree to do this by video conference. Is that understood?
That's correct.
And by the way, Mr. Zamora, this is being broadcast on YouTube. So it is in the public arena, but it is not in the public courtroom. I now show you the defendant's waiver of constitutional rights and court's admonitions. This starts off with the basic information at the top. Then it goes into 3 sentences making declarations. The first one says that you're waiving the right for me to read to you word for word the document that accuses you of driving while intoxicated with a blood alcohol content of 0.15 or higher. That's what you were originally charged with. Second sentence declares exactly that. And then the third one says, I hereby enter a plea of nolo contendere, that's no contest, to the charge of driving while intoxicated. Now, that tells me that Ms. Lee has gotten an agreement for you that the case will be reduced from extreme intoxication to DWI misdemeanor B. Now, the rest of this document is significantly divided into 15 parts or divisions, and each one is numbered. Number 1 talks about the range of punishment. Did you understand the little check mark there says that this is a DWI first, and that the punishment can be anywhere from $0 fine to $2,000 fine, and jail from 72 hours to 180 days in jail. Did you understand that?
Yes, sir.
Now, if you look with me at number 2 in particular, it talks about the rights that I talked about with you a moment ago. The right to a jury trial, the right to cross-examine witnesses, and the right to remain silent. Here you declare, I freely and voluntarily give up those rights. Is that true?
Yes.
All right. Number 3, have you ever had any kind of mental health problems?
No, sir.
Have you ever taken or been given mental health medication?
No.
All right. The rest of these paragraphs, did you read them carefully or understand them with the help of your attorney?
Yes.
All right. Number 8 in particular, where were you born, sir?
El Paso, Texas.
That makes you a U.S. citizen, and I will so note in the documents of this case. Have you ever been involved in any way with the sex offender program?
No.
All right. Number 15, I covered with you. Number 15, you have a right for me to order a risk and needs assessment. You have signed this document declaring that you don't want me to do that you're ready to proceed. Did you understand that?
Yes.
Very good. It is signed by you, your attorney, and the state's attorney, and I will be signing all of these too. Scroll, please. This document that I'm showing you now, again, starts with the basic information. Then it's got a stack of vertical boxes next to it, something to do with the right of appeal. The title of this document is Trial Court's Certification of Defendant's Right of Appeal. That's me. And if you look at the 5th box from the top, I will be marking that one and I am declaring and certifying to you that this is a plea bargain case and you have no right of appeal. Did you see and understand that?
Yes.
We talked about that verbally. Now you see it in writing and you have signed that document. Is that right?
That's correct.
Okay. I now show you a document titled Application for Deferred Adjudication. This document starts off at the top with the basic information, identifying information, and this says deferred adjudication. I want to talk to you about that briefly. First of all, a deferred adjudication agreement is a really good deal that Ms. Lee has gotten for you. Instead of DWI extreme intoxication, which is 0.15 or higher blood alcohol content, she has reduced this by agreement to DWI first, which is a misdemeanor B. The original charge is a misdemeanor, $0 to $4,000 fine and 0 days jail to 1 year. Now it's cut more than half. Even better than that, if you live up to 100% of the conditions of supervision, and I mean that very literally, sir, if you live up to it, you keep your word and do what you're supposed to, then the case will be dismissed. And under Texas law, you have not been convicted even of DWI first. Is that clear?
Yes.
Now, is there a risk? Yes, sir. The risk is that if you screw up, you fail to live up to the conditions or you refuse to do so, either one, then the state can ask me to give you official notice, bring you in for a hearing. And then what will happen is we'll listen to the evidence and give consideration to going ahead and giving you a forever, the rest of your life conviction for DWI first. The only exception would be if you were a really good pal with the governor of the state of Texas and he pardoned you. Otherwise, it would follow you the rest of your life. And you'd be looking at the full range of punishment, $0 to $2,000 fine and jail from 72 hours to 180 days. Is that clear?
Yes.
So you're getting a really good deal. Don't mess it up. Now, we're looking here at personnel data sheet. That is your personal information. It says you're working full-time for Maximus. You're getting $15.47 hourly, 40 hours a week. By the way, Ms. Lee, I appreciate the way that is all filled out nice and neat, no question. Then you've got the information on your references. You got John Zamora, Sonia Rodriguez, Concha Zamora. Okay. You are single, 0 dependents. You don't have any children.
No, sir.
Thank you. What vehicle do you have?
I have a 2009 Pontiac G6.
All right.
Judge,
Pardon me?
Judge, that is something that I wanted to address with you. Just let me know when. It has to do with the ignition interlock.
All right. But the court does note that there's no information on his vehicle, and he has informed the court now in questioning that he has a Pontiac. You may address that issue now.
Okay, Your Honor. He does own a vehicle, but he does not drive. He works for the Texas Health and Human Services Commission, and he works from home. So he has told me that he has gotten rides and he rarely leaves the house. He understands that most likely his license is actually suspended, so he has not been driving because of that reason. So as far as the monitoring device goes, I told him because you have a vehicle, you will have to install that. It's the preferential, I guess, method. So he can do that and just blow into it, regardless of whether he's driving or not. Or if you would rather him have a sober link, then I told him that is a possibility also, since he does not drive or does not intend to drive. Once he does drive and gets an occupational license, then I told him he would have to switch it over to the ignition interlock.
All right. I presume that you heard and understood that, Mr. Zamora?
Yes.
Okay. All right, next document. This is what's called a plea agreement. It has information at the top. The only thing that's missing is the court, but that's not necessary in this particular case. Now, the first two boxes I will have checked off. The first one talks about the right to remain silent and how we've discussed it. Now, this is about third or fourth time that we refer to it. The second little box says defendant is a U.S. citizen. That will be marked also because you have testified that you were born in El Paso and you're a U.S. citizen. The next section says defendant's acknowledgements. There's 5 boxes in there. They again talk about the different rights and protections that you have. You are informed of them by your attorney and by this court. Is that correct?
Yes.
That's where those boxes are all checked off. Now, the state has a motion because this was originally charged as a DWI extreme intoxication. Mr. Edelman, I'm sorry, Ms. Morgan.
Yes, Your Honor. The state moves to waive the extreme intoxication and proceed on a DWI first.
No
Very
objection.
good. There being no objection from defense, the last little box in this area will be marked by the court. The motion is granted. So officially, you are charged only with DWI first. Your plea, or officially, what is your plea again, sir?
No content.
All right. I'll remind you that a nolo contendere or no contest by law is considered a guilty plea, and I will take it as such. Do you understand that?
Yes, sir.
And a nolo contendere, based on that, I could go ahead and enter a conviction right now. Do you understand that as the judge, I have the authority and responsibility to either agree and accept your bargain, or I can reject it. I can also give you any punishment in the proper range of punishment. But if I give you a punishment heavier than what you agreed to, or if I reject your deal outright, the law would allow you to start all over again. So in this case, I am honoring your agreement with one exception. I grant you deferred adjudication for 1 year. You are fined $300. I will not accept the probating of that $300 fine. You will have to pay that. I'll address that momentarily. You'll have to perform 48 hours of community service restitution. The $300 fine, by imposing it and taking off the probation of the $300 fine, I am giving you a punishment greater than what you agreed to. Therefore, you and Ms. Lee could decide to start all over again if that is your choice. Think about it a moment, and then I'll ask you what you want to do. As further conditions, you will, in good faith, enroll in and complete the DWI education program. Now, Ms. Morgan, am I to believe that you're not imposing the victim impact panel?
That's correct, Your Honor.
All right. Then you will submit to a TAP evaluation and follow the recommendations. There will be 6 months of ignition interlock on your vehicle. If you submit, I don't know if you already did, but if you submit a sworn affidavit, maybe that's redundant, an affidavit wherein you swear that you are not driving and will not drive until such time as you have a legal driver's license and you're insured, at which time you will have 6 months of ignition interlock on that vehicle. Is that clear?
Yes.
All right. Now, the supervisory fee will be $34 a month.
The $34 is for what? I'm sorry?
It's a supervisory fee. I believe that's for the probation office, but I'm not certain. I just know it's a supervisory fee required by law.
Okay.
All right. Questions, anyone? Ms. Morgan,
No, Your Honor.
Ms. Hikyu Lee,
No, Your Honor, just wanted to see if he would want to go through with the plea, being that his $300 fine is not being probated right now.
that's what I was gonna ask. Do you need to go to breakout or you want to just ask him out front right now?
I can ask him right now. Arturo, are you okay with paying the $300 for the fine?
Yes. Mhm.
I think
Very
he's
good.
willing to go forward, Your Honor.
Any question from Mr. Zamora? Anything?
No questions at this time.
Okie dokie. Ms. Luna?
Yes, I need to speak to him, Judge.
All right, Mr. Zamora, Ms. Maricela Luna, she's called a CLO, a court liaison officer. She sets everything up for probation. She's gonna
Okay.
visit with you briefly. She's gonna need information, etc., and set you up for the probation. So, you're gonna put him in breakout, Patty? Patricia,
Yes, Your Honor, breakout room 3.
All
okay.
right, thank you, Patty.
Thank
Y'all
you.
go to breakout room 3, and then when you're through, Mr. Zamora, you're excused. All of you, I think this concludes the docket for this morning, right, Patty?
Kind of, sir. I have an announcement. Miss Hikyu Lee, did you want to go with them?
No, I have to go to a different court, actually.
Okay. All right.
Thank you.
Yes,
He'll contact me if he has a question.
Okay.
Thank you. All right.
Thank you. You and your family be blessed, be well, be safe. In fact, all of you.